Hi, everybody. My name is Lauren. I'm the Senior Operations Manager here at BRIC. I just want to take a quick moment to welcome you here to BRIC House. BRIC House is celebrating its 40th year as one of the leading presenters of free cultural programming throughout New York City and the largest here in Brooklyn. Our work, we incubate and present the work of artists and media makers throughout the borough that reflect the diversity that surrounds us. Here at BRIC House, we think of this as our cultural living room, so welcome to our house. We have a public media center up on the second floor. We have a contemporary art gallery right behind me, 2 performance spaces, a TV studio, and artist workspaces. The work we do goes beyond BRIC House and throughout Fort Greene and the borough with educational programming and community-engaged work. One more housekeeping thing to tell you, emergency exits are the front door where you came in. There's one by our security desk and then one out by our cafe hall over there. So that being said, I'm going to turn over the mic and thank you for coming to our house.
Criminal justice, the process by which you are arrested, charged, and eventually go before a jury who render their verdict.
We find the defendant, Robert Brooks, not guilty.
We find Randall Bailey guilty.
We find the defendant not guilty.
Have you reached a verdict? Guilty or not guilty?
I mean, that is just objectively charming, although all these years later, I still can't believe those penguins wrongfully convicted the Central Park 5. Now, whenever we talk about criminal justice reform, we tend to just talk about policing, public defenders, judges, and prisons, and skip over a crucial element there, prosecutors. The attorneys who work for the federal, state, and local government and bring cases to trial. There are roughly 2,500 DA's offices all around the country, and they have a surprising amount of influence at almost every single stage of the criminal justice system, because prosecutors decide whether you get charged and what you get charged with, and therefore heavily influence what kind of sentence you could face. And you sort of know deep down how important they are because of a little phrase that crops up constantly in local news crime stories.
Ultimately, it'll be prosecutors who decide whether charges will be filed.
Prosecutors will decide whether to file criminal charges.
Prosecutors will decide what happens next.
Prosecutors will decide.
Prosecutors will decide. Prosecutors will decide.
Prosecutors will decide. Prosecutors will decide.
Exactly. Prosecutors will decide. It's one of those 3-word phrases that you hear so often you don't even think about what it means anymore, like user agreement update, or some restrictions apply, or Tyler Perry presents. You know, at this point, I'm just going to assume that he presents everything. It's safer that way. I technically think he presents this show. I wouldn't be completely surprised about that.
Welcome to the first, our inaugural event at the Innocence Project, our first Conversations with the Innocence Project, a series of discussions that we will have around the city over at least this year, and if it works out and is of interest to everyone, continuing forward. My name is Maddy deLone, and I'm the Executive Director of the Innocence Project, which is a nonprofit organization that represents people who have been convicted and served time, innocent people, gets them out of prison, and also does a lot of public policy reform work around the country to change the laws that led to the conviction of the innocent, and also to make the system, the criminal justice system, more fair and more just. I'm happy to see that so many of you are here at 6 o'clock, a pretty impressive crowd to be here with us at the BRIC House lobby and stoop, and I'm grateful for those who are joining us via Facebook. And just a reminder, we are Facebook live streaming right now, so thank you very much for joining us wherever you are in the galaxy. We have a great program for you tonight around this issue, the theme of prosecutorial power and wrongful convictions. And without further ado, I'm going to introduce you to the moderator of tonight's discussion, our fabulous, our own Innocence Project Policy Director, Rebecca Brown.
Thank you. Thank you, Maddy. Good evening, and thanks to all of you for coming tonight. And thanks for those of you that are watching us on Facebook Live. I also would ask that if people do want to join the conversation on Twitter, hashtag Innocence Chats. So please join us for what I hope will be an engaging discussion about the role of the prosecutor. As Maddy said, I'm Rebecca Brown. I'm the Policy Director at the Innocence Project, and I'm joined tonight by a distinguished group of panelists who are going to help us examine this issue from a variety of perspectives. So, to my left is Jabbar Collins, our first panelist, and he is a legal analyst who works at Horizon Research Services. Jabbar was also exonerated in 2010 for a murder he did not commit and for which he spent 16 years behind bars. He will be sharing his personal experiences with us and discussing the prosecutorial misconduct that was present in his case. To his left is Cynthia Jones, a professor of law at American University, where she teaches evidence, criminal law, and criminal procedure. You can read her extensive bio in the program, but most relevant to tonight's conversation is her scholarship on wrongful conviction, criminal discovery, and eliminating racial disparities in the criminal justice system. Professor Jones previously headed the Public Defender Service in DC, and so in addition to her academic credentials, we really do welcome her perspective as a former defender. To her left is Nina Morrison, who's been a staff attorney with the Innocence Project for 17 years. She has freed more than 25 people from prison based on DNA or other newly discovered evidence. Woohoo! And more recently, Nina's work has focused on the intersection of prosecutorial power and wrongful convictions, working to bring greater accountability to those prosecutors who commit serious misconduct and to support the work of prosecutors who are seeking to rectify and prevent wrongful conviction. And finally, Joaquin Sapien has been a reporter with ProPublica for a decade now, covering a range of issues from criminal justice to the environment. Joaquin wrote a fascinating series on prosecutorial misconduct here in New York City, and we're really eager to hear his journalistic perspective. So please join me in welcoming our wonderful panel. So I'm just going to take a couple of minutes just to introduce you a bit to the issue and orient the conversation, and then we're going to turn it over to the panel. Prosecutors in the United States are arguably the most powerful, yet least understood political actor by the general public. There are 2,800 people elected to prosecutors' offices in the United States. A total of 30,000 prosecutors work in these offices, and they make daily determinations that affect life and liberty. Interestingly, much of the criminal justice reform conversation is really focused on policing on one end and parole on the other, without much attention to what happens in the middle of the system, namely charging and prosecuting, which really affects convicting and sentencing. It's really where a huge degree of criminal justice policy is meted out, and the prosecutorial role is really central to any earnest conversation about criminal justice reform. With 12 million people arrested each year and 600,000 annual admissions to prison, we must also understand the office of the prosecutor beyond the prosecution of individual cases and understand the prosecutor's role really as a policymaker. How does the office make decisions about how to charge? What arrests are classified as felonies that would have been classified as misdemeanors or not even as crimes at all in the past? What discretionary decisions are leading to an increase in pretrial detention, yielding more and more guilty pleas, including, tragically, from the innocent? Over the 1990s and into the 2000s, prosecutors started charging a lot more arrests with felonies. According to data collected by criminal law professor John Pfaff, in 1994, about 1 of every 3 arrests turned into a felony case. And by the end of 2010, it was 2 out of every 3 arrests. Today, defendants choose trial in less than 5% of all state and federal cases. And that's as opposed to 30 years ago when about 20% of people were choosing trial. So the vast majority of cases are really handled through plea agreements. And this should really give us pause, particularly from an innocence perspective. We know that 11% of our clients, and that's more than 350 DNA-based exonerees, pled guilty to very serious crimes like rapes and murders. So when you think about that number spread out across the entire criminal justice system, where there are less serious charges that people are facing, the number of innocent people pleading must just be extraordinary. And we should consider that this isn't just an innocence issue. Are we criminalizing behaviors we previously would not have criminalized because our system is simply growing? Conversely, what are some of the excellent steps being taken by some prosecutors' offices to decarcerate and to protect the innocent? Relatedly, and throughout this discussion, all of our panelists will be talking about the disproportionate impact that prosecutorial power has on people of color. And of course, we must also think about prosecutorial decisions and behavior in individual cases. While most prosecutors are going about their work conscientiously, prosecutorial misconduct is a major cause of wrongful conviction, often due to a failure to disclose favorable evidence to the defense, known as Brady evidence, that might help to prove innocence. As one of our panelists, Cynthia Jones, says, quote, "In the overwhelming majority of cases, prosecutors face few, if any, adverse consequences for Brady violations, either within their offices or from an outside entity with the power to address their misconduct." To illustrate this, let's turn to a short piece again from John Oliver, a man who's arguably one of the most credible media sources on criminal justice reporting today.
When prosecutors do withhold evidence, there is very little accountability for them. Take Michael Morton. In 1987, he was wrongfully convicted of his wife's murder after the prosecutor in that case withheld crucial pieces of exculpatory evidence. Now, the good news is that prosecutor, Ken Anderson, was held to account for that misconduct. The bad news is there was a slight discrepancy between the two men's sentences.
Morton served nearly 25 years in prison, 8,995 days. And now the sentence for the prosecutor, just 10 days in jail for contempt of court.
10 days, and he served less than half that. Although, before you get too mad, he did also have to pay a $500 fine, which isn't really the penalty you'd expect for wiping out 25 years of someone's life. And to make it even worse, Anderson is actually the only prosecutor to ever serve any time for misconduct resulting in a wrongful conviction ever. Because the truth is, prosecutors rarely face any sort of consequences for misconduct. State bars are supposed to hold them accountable, but a study of 5 states found that in 660 cases where courts had confirmed prosecutorial misconduct, the number of prosecutors disciplined in those cases was 1. And that lack of accountability can fuel a dangerous culture where wins are already prioritised to a disturbing degree.
Well, John Oliver is an American treasure and really helps to set up this conversation nicely. So I'd like to really begin with Jabbar, who has a personal experience with a wrongful conviction. And if you wouldn't mind sharing with us a bit about that and also the particular role of the prosecutor in your case.
Sure. In March 1994, a rabbi was killed in Brooklyn as he collected rent in a building he owned, and the police immediately began to make it a high priority case at the time. The police had initially identified 2 local brothers who were wanted in another robbery in connection with the crime, but once those 2 brothers invoked their right to silence, an anonymous call came into the precinct identifying me as the perpetrator. I appeared at the precinct. I was initially placed under arrest. There was a surviving victim who had said that he had stabbed the perpetrator twice in the back, and I didn't have any stab wounds on my back, so I was released. But 3 weeks later, the police came back to rearrest me. And ultimately, I was arrested and held on Rikers Island for a year without bail. And they produced 3 witnesses to testify against me. One witness had claimed that prior to the crime that he had overheard me agree to commit the crime. And 2 other witnesses had testified that they were outside of the building where the landlord lived, and after hearing gunshots, they saw the perpetrator flee out the scene. So during my trial, one of the individuals who testified against me, I was familiar with him from the neighborhood, but the other 2, I had no idea of who they were. And I remember sitting through trial wondering what was the motivation for these people to come in and lie, because I knew there had to be some explanation for them to come into the courtroom and lie. But the prosecutor at my trial, Michael Vecchione, who was at the time the chief homicide prosecutor of the Kings County District Attorney's Office, represented that all of these witnesses were testifying as good Samaritans, that there was absolutely no undisclosed reason they had for testifying. They were just coming in, talking and telling what they heard out of the goodness of their own heart. And my lawyer, who would later go on to be found to have been ineffective or to have committed legal malpractice in 2 later cases, he was overwhelmed, he was underprepared, and I was convicted. I was convicted at 21 years old and sentenced to 34 years and 2/3 to life in prison. So what that meant is that I had a life sentence, and I would have to serve 34 and 2/3 years before I would be eligible for parole. And at that time, my whole life was destroyed. And I remember making a decision that day. I said that no matter what happened, no matter what happened, I had to become my own attorney. So when I went back to Rikers Island, I got my hands on everything I could regarding the law. And specifically, I'm referring to post-conviction, appellate litigation, and civil rights litigation. And I was fortunate enough to have read a book by F. Lee Bailey when I was on Rikers Island called The Defense Never Rests. And he said something that always stayed with me. He said, no matter how brilliant the attorney, no matter how brilliant the strategy, if the attorney has not conducted an adequate factual investigation, then the defense is doomed to failure. And that stuck with me because I didn't know what these witnesses' motivations were. So I spent the next 16 years of my life dedicating myself to studying and to gathering all the information I could through freedom of information law lawsuits, through civil rights lawsuits, using some of the same tactics that journalists use. I would buy books on investigative journalism. I would buy books on tracking people down, and I did everything I could to get my hands on the paper, the documents that demonstrated what had really happened. And this is what I found out about each of the witnesses. Regarding the witness who claimed that he overheard me agree to commit the crime, I found that when he had actually been arrested 3 weeks after the crime was committed for committing a robbery in that same building. So the police began to question him about that particular robbery. He was going through heroin withdrawal at the time, and the detective promised that if he signed a statement implicating me, that they would dismiss all charges, that he wouldn't be charged with the robbery. He was under investigation for 2 robberies. He was a predicate felon, and he ultimately pled guilty and received a 1-year sentence for 1 to 3 years. Prior to trial, he had made work release, and he was free, but the prosecutors took him into custody and threatened that if he didn't testify at my trial, that they would send him back to prison. So at that point, he recanted the initial statement and told them that the detectives had forced or fabricated that statement and that it wasn't true. And the prosecutors carried through with their promise. They had him suspended from work release and shipped back up to upstate prison, and his release was contingent on him testifying at my trial. Yet at the time he testified, he swore under oath that he had received nothing in exchange for testifying, that there was no undisclosed motivation, and that his release was totally up to the parole board, who he would appear before years later. The second witness I found out, the witness had claimed he had been in a store when he heard gunshots and that he was on the telephone speaking to a 911 operator. Well, I finally obtained the 911 tape, and there was never any call originating from that store. He lied about that. But I also found out that 2 weeks before trial, this witness refused to cooperate as well, and the district attorney obtained a secret material witness order, and that's a court order that allows the prosecution to take a witness in custody to secure his testimony. And while that order is legal, it should be disclosed to the defense so the defense can have an opportunity to cross-examine the witness about that at trial. And they presented the entire false narrative about him too. He was actually kept in detention in hotel custody for I think 2 weeks before trial, and he finally testified. And the last witness, the witness who was across the street, we found out that he had initially came forward only 3 weeks after the crime as well, asking for a reward leading to an arrest in the crime. And once he found out there was no reward, he had left to Puerto Rico, and he had violated the terms of his probation. The prosecutors in my case went to Puerto Rico. They brought him back and promised that if he testified, that they would eradicate all of his probation problems. And that's what happened. None of this was disclosed to the jury, and so the jury never had a chance to evaluate what happened. And as bad as that was, virtually every appellate prosecutor who handled my appeal covered that information up as well. They never disclosed it, and under our law, prosecutors have a continuing obligation to disclose Brady material or exculpatory material. Yet these prosecutors, most of them, who handled my case, failed to disclose that to any of my attorneys. We finally, in 2006, we filed a motion to vacate my conviction, and it went before a judge who ultimately denied that motion. And in addition to denying that motion, he actually precluded me from filing any additional lawsuits to gain information about my case, something that the district attorney didn't even ask for. But obviously, I mean, he couldn't do anything. I mean, I was in prison already, so I didn't follow the order in the first place. So we ultimately brought a federal habeas corpus petition, and we had the privilege of being before Judge Dora Irizarry in the Eastern District, and she finally treated the case with the seriousness with which it was due, and she ordered a hearing on our petition. And rather than have that hearing, the prosecutor or the DA's office offered me a plea bargain. They offered to release me from prison if I were to plead guilty. And I refused the plea offer, and they then consented in an attempt to avoid that hearing. But once it became clear that the prosecutor would actually have to testify in court, they finally threw in the towel, and they consented to a full dismissal of my case. And in 2010, I came home.
You know, Jabbar, you really touched on this in what you just said, but I really do want to highlight this for people in the audience. Can you talk a little bit about the difference in the information that you got about the facts of your case at the time that you were fighting for your liberty versus after your wrongful conviction was revealed?
Sure. After my exoneration, I brought a civil suit against the city and state to recover damages for my wrongful conviction. And in the civil context, the standard for discovery or the standard for gaining information about a case is any information that may be relevant to that case. So there's a huge amount of information that a plaintiff in a civil rights case can acquire during the course of the litigation. You have the power to conduct depositions where you can subpoena witnesses and they have to come in and answer questions under oath. It's totally different in a criminal case. Generally, there's no right to discovery in a criminal case, and usually it's the only information you're entitled to is information that's specifically designated to be disclosed by statute or by a Supreme Court case or New York State case law.
Right. Well, thank you. And Joaquin, I just want to turn to you. You did a big series in ProPublica about prosecutorial misconduct here in New York City that covered a 10-year period. Can you share your findings with us? And also, what I recall about reading your piece was just how difficult it actually was for you to find those instances of misconduct. Can you talk a little bit about that too?
Sure. So we actually got our methodology from a Northern California Innocence Project study that had been done a few years prior. And what a group of researchers there did was that they had gone through basically every appellate court decision that had been made in the 10 years prior. And they used search terms like Brady and statutes that would have to do with suborning perjury and other instances of prosecutorial misconduct so that they could develop a list of cases where appellate courts had identified that prosecutors did something wrong at trial. And I can't remember exactly how many cases, but they found hundreds of cases where appellate courts found that there was at least an allegation that the prosecutor had done something. And then in a smaller group of cases, they found that even though the prosecutor had violated the rules at trial, that the conviction was so strong that they upheld it anyway, which is pretty common. And far more common than those cases where a conviction is actually overturned as a result of misconduct. And so we did that here in New York, and we found more than 50 cases, and this is a small number compared to all the cases the appellate courts heard in this time period, but they found 50 where they had identified some form of misconduct. And upheld the conviction anyway. And then we found another 30 where that conviction was overturned. And so that's a pretty high bar. I mean, it takes a long time to get, as Jabbar can attest, it takes a very long time for an appellate court to even hear your case. And then to overturn the conviction, particularly at a state level, is very unusual. So typically, there's pretty strong evidence that the prosecutor did something against the rules. And so we looked at those 30 cases to get a sense of the severity of the misconduct, but that was just the tipping point, and that took quite a long time just to get to those 30 cases. So then to get a sense of what happened at trial, we had to go into the trial records, which meant going into the courthouses, which meant paying 25 cents a copy to get the original documents from a case that was, that happened in 1991 or whatever it might be. None of this stuff is digitized. There's no electronic record of it. But that's really the only way, aside from the decision itself, that you could try to piece together what happened. Namely, who the prosecutor was. Because the prosecutor's name is almost never in the appellate court's decision once they overturned it, even though they're the person that withheld the evidence or did whatever else it might be. So we had to identify the prosecutor that way. Then we took the name of the prosecutor and we did two things. One was we went to the disciplinary committees, which in New York are actually a branch of the appellate courts. So the same entity that overturns these cases based on misconduct is also more or less responsible for punishing them. But they operate largely in secret. It's impossible to see the complaints that they get unless they issue some form of public sanction. Again, very, very unusual. So of those 30 prosecutors, we found one who had been punished by the disciplinary committee. He was a fairly low-level guy out in Queens. His name was Claude Stewart, and he was actually tied to several cases in which convictions were overturned before anything happened to him. And he had been, as it turned out, censored once, but we never would have been able to find that out had he not been more formally and robustly sanctioned later. So then the next step for us was to take these 30 prosecutors and foil the district attorney's office to see if they did anything. Because what most prosecutors' offices will tell you is that, well, we handle this internally. If somebody breaks the rules, if they get dinged by an appellate court, that's a really big deal. That's going to damage their career. That's what they'll tell you through the communications office. A lot of the time what you'll hear from people who've actually worked in these district attorney's offices is that in some cases it's kind of a badge of honor, that you were really willing to kind of push the envelope. And so what we found was that overwhelmingly the majority of these prosecutors went on to have very successful careers in the district attorney's office. And after they left, some of them became judges, some of them became very high-profile lawyers or high-profile defense attorneys. And so there really was no evidence that the district attorney's offices themselves had done anything in response to this kind of misconduct. Most of it had no effect on their salaries or promotions or anything like that. So then we were able to take those 30 cases and kind of dive into the consequences for the individuals who were wrongly convicted. And, you know, aside from having to serve years in prison for crimes they didn't commit, there was one guy who actually got out early for a crime that he did commit, which was, you know, an experience in reporting that I'll never forget, because his conviction was overturned and he had served 10 years at that point, and so he took time served and got out. He had been accused of murdering someone, and then he later told me, you know, in the course of photographing him, up until this point, I had bought the story that he was totally innocent of this crime, that in fact he did kill the guy that he was accused of killing, and that he got out early because of the misconduct committed by the prosecutor. I think that's terribly unusual, but it does apparently happen. So, you know, it sort of adds to the array of reasons to be concerned about this sort of thing, beyond the fact that, you know, people who are innocent go to prison. You know, typically there's somebody out there that's so guilty of this crime that's out there. So the last thing I'll say is that, you know, the reason, so first of all, it's really hard to identify these instances of misconduct, and a big part of that is that there's so few cases that actually go to trial to begin with, right? So you're really not going to see, I mean, what we saw really is probably the tip of the iceberg. I mean, the same kind of prosecutorial practices that led to these wrongful convictions are often used, but we just never really see them because they never see the light of day.
Right, thank you. And Cynthia, this is really a related question. You've argued that the government's duty to disclose favorable evidence to the defense under Brady is really one of the most unenforced mandates in criminal law. So what do you mean by unenforced mandate?
So in a criminal case, and Jabbar spoke a little bit about this, the prosecutor gets all of their investigation and all their information from the police. Those aren't public records. They keep a file. The judge never knows if there is a witness who's been given $500 or promised treatment. That's all in the prosecutor's file. Under the law, the prosecutor has an obligation to look through that file and say, I have to turn this piece of paper over. And it's an honor code system. If they don't do it, we'll never know they didn't do it because we don't have that file. The judge doesn't look at that file. And the Supreme Court has said there's no obligation to have an open file system where you just give everybody all of the information in your file. So we're relying on the integrity of the prosecutor to diligently look through their file and turn over information to the defense that exonerates the person or is simply favorable, helpful to the person. Maybe it doesn't prove they didn't do it, but it might be helpful to the defense. What we're finding is prosecutors are not doing that. They're not going through their file. In many cases, wrongful convictions cases and just wrongful arrest cases, we're finding that the defense stumbles upon this information independently. So the prosecutors had it, it's in the file, they knew about it. In a famous case out of Louisiana, a guy's been on death row. And the original prosecutor, when he found out he was dying of cancer and had 3 months to live, told one of the other prosecutors, we withheld information that would have not necessarily exonerated this guy, but would have made him ineligible for the death penalty. Now that I'm dying of cancer, I want to, unburden myself. His co-prosecutor that he told no one and continued to suppress that information until the defense investigator found it independently. That happens more frequently than we know and than we will ever know. We don't know how many prosecutors. I'd like to believe that many prosecutors are diligently doing their job. But when they have that file and you don't have that file, you don't know how many of them are withholding information. And this is an adversarial process. As a defense attorney, as a public defender, it's me against them. I'm trying to win and they're trying to win. But the court says, prosecutor, you're not supposed to be trying to win. You're supposed to be trying to do justice. And if it's just that you turn that over, you have to turn it over even if it hurts your case. And the temptation to win and keep that piece of paper that no one may never find out about is so strong that many prosecutors do not turn it over. And we know it's many because every time we discover it accidentally, some office will say, that was just a rogue prosecutor. I'm like, how many of them are rogue? I mean, at some point, all of them are rogue. I don't know that I would trust anybody to turn over information that would cause them to lose a trial that they want to win. Think about that. Like, I am all set. I believe he did it. I believe in my heart he did it. Even though I have witnesses who are compromised, I believe he did it, and I want to win, and it's going to help my career if I win this case. But I have this information that might cause me to lose. Do I turn it over to the defense and lose, or do I just keep it in my file and hope no one ever finds out? That's the moral dilemma that prosecutors are in. And so as a result, most Brady violations, that's the violation of the duty to turn over this information, are undiscovered. And even when they are discovered, even when you catch them red-handed and you say, aha, look at this, you knew about this cop, he destroyed evidence, you knew about it, and the prosecutor's like, I didn't realize, I apologize to the court, here it is, you can have it now. And judges, they scream and rant, and you should have turned it over. Okay. They have it now. Let's just all get back to the trial. I'm thinking, shouldn't there be some ramification for doing this? And there's not. Judges don't exercise their authority to punish prosecutors for withholding this evidence. The DC bar and the New York bar and the disciplinary authorities, they're not holding prosecutors accountable. It just gets dismissed. And so what is the incentive for that same prosecutor the next time to turn it over? Nothing happened to me, nothing happened to the guy down the hall. We're going to try it again. Maybe this time the defense won't find out about it and the defendant will just do his time and this case will go away. So it's an unenforced mandate because the Supreme Court says, prosecutors, you absolutely have to turn it over, and prosecutors don't turn it over and nothing happens. The courts don't do anything, and outside disciplinary authorities don't do anything, and prosecutor offices do not take any action, we now know.
So follow-up. So you talk about sort of the temptation not to disclose. You know, what are some of the things that judges can do to enforce this or other criminal justice actors?
You know, I've written a lot about this. Without there being a change in the law, I worked for 3 years to create a rule to force prosecutors to turn over this exculpatory evidence. These are federal prosecutors in D.C. The Department of Justice fought it tooth and nail. They won. So the rule ends up being very narrow and not good enough of an incentive for prosecutors to turn it over. And so I thought, we don't actually need a rule. Judges could say to prosecutors, I want you to certify that you have turned over everything, and I want you to make that certification in my courtroom under oath. And if you lie under oath, that's a crime. A judge can hold you in contempt for lying or saying that you did it and then not doing it. So judges have a lot of power that they're not using to hold prosecutors accountable. You could, I mean, I don't care if you're like the most, badass rogue prosecutor. Very few of them want to lose their license to practice law or be held in contempt. And so very few of them are going to actually lie in court. But judges will not put them on the spot and force them to make an admission on the record. And that's one of the things that's in the arsenal of judges. And judges could also create what I think would be easy to do, a Brady violators list. So one prosecutor commits misconduct in Judge A's courtroom. And then he says, I didn't know I had to turn it over. I didn't know that this was included. And the judge is like, all right, we're going to let it go. We're going to let it go. They go to Judge B's courtroom. Your Honor, I didn't know. Judge A and Judge B don't know. There should be a list in that courthouse of every Brady violator and what happened to them. So judges can see, wait a minute, this is a pattern. You're doing this a lot. It is now time for somebody to sanction you. This is not an isolated incident. Those are a couple things that judges can do without there being a change in law. That could be done right now.
That's great, thanks. And Nina, where does the Innocence Project come into all of this? What is some of the work that the Innocence Project is really doing to prevent wrongful convictions due to prosecutorial misconduct?
Sure. Hi, everybody. Thanks for coming. So we're doing a few things in this area, a little carrot and a little stick. So on the carrot end, the good news is there are actually some really terrific, in many cases, newly elected prosecutors who came in on a wave of outrage about cases like Jabbar's, including in our home city of Brooklyn, where we are tonight, determined to do better and to prevent what happened to him from happening to others. Really, in large part, a confluence of events, people concerned about mass incarceration, about not just cases like Jabbar's where an individual is wrongfully convicted, but whole communities of color and low-income communities in particular, that were affected by over-policing and over-criminalization. And what we saw was that when the system was overloaded, especially in the 80s and 90s, at the time when Jabbar was prosecuted, that was a time when, if you're going to have that volume, all of us who are busy people know the busier you are, the more likely you are to mess up something on your to-do list or forget to do something important or just not do as good a job as you can. And so we are both seeing new prosecutors that are coming in, trying to get a smaller number of cases right, and also putting in policies like transforming their discovery practices. So even if the law doesn't require them to turn over evidence before the trial starts, prosecutors can, as a matter of just the directive from the boss, say everyone who works for me has to turn this over within 10 days of getting that information from the police. There's no law that prevents them from doing it, and they can come in as the representative of the people to do that. On the back end, we are seeing prosecutors who are starting what are called conviction integrity units. These are special units in the office, separate from the appeals division, which typically comes in and, the state versus so-and-so. So they are the state, and they are there to defend against a post-conviction petition brought by a prisoner who says I'm wrongfully convicted or my rights were violated. And typically the appeals division will come in and look for reasons, like good lawyers do, to give the courts to reject the petition. There is a new wave of these units that are created not to oppose, but to investigate, to look into, is there new evidence that hasn't been provided to the defendant before that could prove their innocence? Are there things that nobody knew about, like forensic DNA testing that we could do in 2018 that wasn't available 10 or 20 years ago? And we have worked at the Innocence Project both to help create and mentor a number of these units and also to investigate individual cases. So to give you an example, 3 weeks ago I was in Texas Texas, in which a longtime client of mine, a man named John Nolly, was exonerated after 21 years since his arrest. He got out of prison on bond by the state's agreement about 3 years ago, but he was fully cleared of the charges and declared actually innocent by a conservative Republican district attorney's office who had created a conviction review unit that had done many, but two in particular, incredible things in this case working with us. One was that they had gone through and dug through old files in the office, not to oppose the petition of people like Jabbar, trying to find out what had happened and why had these informants who claimed that I said all this stuff I didn't say actually lie. They went on their own and dug up the information that I always suspected was there and had some ideas on where it might be hidden in other files in the office that didn't even involve this case, but that related to the original informant who made up testimony against my client and who lied and said he had never ever, this will sound familiar to you, never in my life have I ever tried to work a deal or inform on anyone. And it turned out he had offered to help in more than 12 cases and had testified in one and given a signed proffer in another. And the DA's office, to their credit, didn't hide that information. When they found it, they emailed it to me. She called me up and said, check your email, I got something interesting coming. Opened it up and there it was. And we didn't have to go to court and fight. They agreed this conviction should be thrown out. The other thing they did that was incredible is they went back and they reinvestigated the case with us, did a ton of interviews, a ton of forensic tests. We had an agreement that we were going to do this outside the court process and outside the media process and get to the truth. And at the end of the day, they came to the conclusion that there was absolutely no reliable evidence against my client. And I will say we didn't have bombshell DNA. We didn't have proof of who did it. We still haven't solved the crime. But they decided there was no reliable evidence. This man did do it. Lots of other suspects more likely to have done it. And they were going to declare him innocent. So I don't want to be too Pollyanna because we've had a lot of more cases that look like Jabbar's than ones that look like this one. But the wave of the future is here in many places, and it's in some unexpected places. So that's the good news. We also are seeing, I will say, just on the day-to-day, it is changing slowly but surely. Line prosecutors coming of age in an era where they have grown up seeing the faces of men and women who've been exonerated of crimes they didn't commit and the human devastation that results, who I think really do care and don't want to be the next Ken Anderson, you know, the guy who put our client Michael Morton away. They don't want to be that guy because they don't want to be that guy because it's a horrible thing to do. They also don't want to be the guy who goes to jail even for 8 days and loses his law license. We are currently working as co-counsel for a man named Eric Hillman who was fired from his job as a prosecutor in Texas because he refused to hide evidence of a defendant's innocence. And we're actually doing an employment case that's getting argued in the Texas Supreme Court next week, helping him sue to try to get his job back, because right now prosecutors like Eric Hillman have no job protections in the state of Texas. But we are actually hoping that the Texas Supreme Court is going to say this is too important to let people like him get fired. Then on the stick end, we are trying to use the bar discipline process a little more actively than it has been used. You know, as Joaquin mentioned, very often nothing happens and it happens in secret. We are working to try to bring some, shall we say, stronger arsenal to the team to get these bar complaints drafted and filed. A lot of defense lawyers, you know, legitimately so, are very fearful of filing a complaint against a prosecutor because maybe that person violated their client's rights today, they caught them red-handed, the client might have gotten a really favorable plea or gotten the case dismissed, but they've got to come in and litigate against that person 10 more times next week, and their colleagues the week after, and the week after that, and the week after that, and they don't want to be the pariah who is literally the tattletale or the snitch or caused all this trouble. So we at the Innocence Project, because we represent people 10 or 20 years after the fact and have a lot of independence and aren't paid by the government, can go in and file these complaints, you know, not willy-nilly, but with a measure of independence and some resources behind us. So we filed a handful of them this year in some pretty egregious cases, and we'll see how they played out. And I think in those cases, we're focusing on ones where people were wrongly convicted and there's an acknowledged wrongful conviction or exoneration, and or where there's been a judge who's already found egregious intentional misconduct, not a mistake, not negligence, but someone who deliberately and intentionally broke the law. And if the bar doesn't do anything about those cases, I think we'll have, you know, a little more data to talk about some of the broader reforms.
Great, thanks. And this question really goes out to all of you. Can you talk a bit about the disproportionate impact that prosecutorial power has on people of color, and really in two areas? First, as they're in their overrepresentation as defendants, but then also in the ways in which bias can really infect prosecutorial decision making.
So frequently people ask, why are there racial and ethnic disparities in the criminal justice system? Is it because the cops and the judges and the prosecutors are all racist? And I say no. That's not what it is. There's only really one reason that there are racial and ethnic disparities in the criminal justice system, and that is discretion. Who has it and how they wield it. We don't want a system where there's no discretion, right? That looks like everybody gets arrested, everybody gets charged, everybody gets one sentence. We don't want that. So judges and police officers and prosecutors have to have discretion, but they're human beings. They come to their job with the biases that we all have, implicit biases and sometimes explicit biases. So if you have a bias against a person of a particular racial or ethnic group, and you have discretion, how do you think that's going to come out? Right? You may not say, I'm doing this because the person is Latino, but you have a bias against people who are Latino, and you have discretion over whether to charge it as a felony, and what kind of plea offer to offer. That abuse of discretion that begins the moment a police officer decides to stop a car or to make an arrest, to whether the prosecutor charges, and it exists throughout the criminal justice system. And you look at these news stories of people being exonerated, and we want to cheer and feel good. Go back and look and see how many of them are black men coming out. It's a disproportionate number of black men who are wrongly convicted. I'm not saying that, all of those people conspired to convict black men. I'm saying that because you have discretion and you have bias, it infects the integrity of the justice system and results in a disparate impact on people of color.
And I'll just say on that point too, there's some data on our website. We did a study about 2 years ago looking at the DNA exonerations in this country to that date, and found that black men were disproportionately represented in the pool of exonerations, people exonerated by DNA, not just above their numbers in the population as a whole, but above their numbers in the prison population. So the numbers who are wrongfully convicted go even beyond the rate at which we incarcerate African Americans generally. Our data set is small. It's a tiny percentage of all the people prosecuted in this country because it is so hard to exonerate people. It's just the tip of the iceberg. But at least anecdotally, it suggests that we are seeing significant disparities in who not just gets charged and convicted, but who gets wrongly convicted. And the other place that we see a lot of it, again, it's hard to study systematically because exonerations are by definition an undercount, is in the race of the victim. This has been studied in the capital defense community a lot. I was struck by when you were telling your story, and I love my rabbi. I like to think that my rabbi and everybody else's murder would be prosecuted equally, but I couldn't imagine, and I don't think I've ever heard of a case where a low-income man of color was murdered and prosecutors flew to another country to get the witness back, right? And made deal after deal after deal for all these witnesses. We tend to see it much more, and again, because of our unconscious biases and the ones we're raised with about whose lives matter more, we see it much more with a child who is murdered, a white person, a person of privilege, or someone who's connected, because electoral officials, they are connected to a powerful segment of society, and when someone of means is the victim of a crime, it's the cases that people are under pressure to solve and to win is where you see people cross the line. Again, not because they're evil, not because they're bad people, but because that's human nature.
I think it's pretty clear. There's a lot of evidence that people of color are disproportionately affected by the criminal justice system writ large, and so that they're disproportionately affected by prosecutorial misconduct should really be no surprise. I'll say this, of the 30 people that we found who were wrongfully convicted, all of them were people of color. And many of the prosecutors were white.
No, I can't add anything to that. You covered it all.
Well, Cynthia, I wanted to pivot from misconduct, so prosecutors who intentionally do something wrong, to really the broader issue of, prosecutorial power and discretion, really the role of the prosecutor as policymaker. Can you talk about the discretion and power prosecutors have at both the charging and trial phases?
So a lot of the power that prosecutors have is independent of the role of the judge. People think, the judge is the boss of the courtroom, the judge is sort of, reigning over everyone, and that's not the case. The prosecutor is the most powerful actor in the criminal justice system because a prosecutor can stop the case from ever getting to court. And then once it gets to court, depending on what the prosecutor charges, and most crimes that are committed, it's actually not one crime. It's, you had a gun, that's a crime. You hit someone, that's a crime. You tried to rob them, that's another crime. A prosecutor can decide under what statute to charge you under so that by the time you get to court, the judge's hands are tied. Because they charge that crime, you have to be held pending trial, and the sentence has a mandatory 5 years. So the judge is pretty much a functionary, and it's the prosecutor who's driving all of the key decisions that are made. They can change the entire adjudication trajectory of your case, from whether you get bail to what sentence you get. And if you look at any stage in that process, it is the prosecutor's power that's making the biggest impact on how that case comes out. And the prosecutors are part of the executive branch. They are elected. They're not controlled by judges. There was a television show I watched recently. I use a lot of pop culture clips in my classes, and my students will say, "Oh, Professor Jones, look at this particular episode of Law and Order. It's wrong." And I'll look at it. I'm like, "Yeah, you're right. That is wrong." The judge is ordering the prosecutor to bring charges. I'm like, "Yeah, right." That doesn't happen, and it couldn't happen. The prosecutor has independent authority to decide whether to bring charges or not. Even if the prosecutor believes that a person committed the crime, they can decide, "I'm not going to bring charges." That's their independent authority. That's a lot of unchecked power. If you think about it, if a judge commits an act of misconduct, it's public, we're all over it. Defense attorneys, other people, there are accountability mechanisms. There's very little that can be done to hold prosecutors accountable. And so you have a lot of unchecked power that needs to be regulated, I would argue, a whole lot more.
And speaking of unchecked power, of the nearly 3,000 prosecutors that are elected, 80% of them run unopposed. And so my question is for Joaquin, which is, that we are seeing a new exciting wave of progressive prosecutors being elected from Houston to Chicago. Clearly, there's a role for the media in educating the public about the role of the prosecutor. What do you think is the best or most effective way the media can do that? What should it be reporting about? What should it be telling the people about?
That's a good question. I mean, I think, the evidence here in Brooklyn that the media can make an enormous impact when it comes to prosecutor elections is pretty clear. I mean, we had a district attorney in Charles Hines who had been here, I want to say 40 years. Close?
20 plus.
Close to 30? Yeah. I'm sorry. He'd been a public figure for a long time. Yeah. Anyhow, and he, in the majority of those elections, he won by a landslide up until a lot of the coverage around misconduct in his office. I think that made an enormous impact in voter turnout. The Times had done a bunch of stories on Louis Scarcella and the wrongful convictions that he was involved in, and I think there was more attention on that office and some of the things that they had done than there had been probably ever in the course of the 25 years that he was in office. So it makes a big difference.
Can I just add one thing? A lot of times when prosecutors, almost all the time, when they run for election, it's get tough on crime, 3 strikes, I'll lock them up. Lock them up and throw away the key. I think the media and the public, we need to change the metrics in terms of how we're evaluating whether somebody would be a good prosecutor or not. We should start looking at, were there any wrongful convictions based upon cases you handled as a prosecutor? Are there racial and ethnic disparities in the decision making? Was there evidence not turned over? all of those things we need to start looking at, and the media should start reporting on. So when you're evaluating whether you want someone to be your prosecutor, you have the information that you care about. But I think if we just let them get away with lock them up and throw away the key, then there's not much to measure on. We get what we pay for.
Jabbar, this question's for you. You really litigated your case in many ways in sort of the court of public opinion here in Kings County. And I'm just wondering personally what that felt like and sort of how you handled that.
Sure. Actually, this involves the question you posed to Joaquin earlier. The media can be extraordinarily helpful in bringing to light the injustices in these cases. You know, when I initially gathered the evidence I had, and I realized that I had enough to establish not only that I had been wrongfully convicted, but that this was intentional misconduct, we made a strategic decision that we would litigate this both in court and in the court of public opinion. Because the prosecutor who committed this misconduct in my case was such a high-ranking prosecutor, not only did it demonstrate I was wrongfully convicted, but we believed that there were tons of these cases. So we made a strategic decision to litigate this. And at the time, the prosecutor who convicted me was handling a judicial corruption investigation in Kings County. So all of the judges in Kings County were potentially under investigation for buying their judgeships. So, you know, we thought that this would give any judge who had the case an incentive to rule in the prosecutor's favor. So we felt that it was necessary to do that. After my conviction was overturned, again, we wanted to make sure that the public understood exactly what happened. And part of that was just personal because, you know, they had taken so much of my life away. So the last thing I wanted to do was to allow them to sweep this under the rug. So the Wall Street Journal had published a story about me. And Ken Thompson, who would ultimately become the next Brooklyn district attorney, had read the story, and he was so outraged at what had happened that he reached out to my lawyer, Joe Rudin, who would have loved to be here tonight, but he can't. And he said he wanted to run for the Brooklyn district attorney. Now, at that time, a DA hadn't been, an incumbent district attorney had not been unseated for over 100 years in Brooklyn. There had never been an African-American district attorney in Brooklyn. But Ken said that he would make wrongful convictions a priority. So we began to litigate on two fronts. While we were litigating in court, we developed relationships with reporters, and we would send them all of our court filings. You know, we made ourselves available for interviews, whatever we could. And it, like from 2010 to 2014, virtually at least once or twice a month, there was a story about the case. And it happened to be at the perfect time because Hines was up for re-election. And it started a tidal wave. And what happened was we began to receive anonymous calls of people coming, you know, people from his office would actually call our office and give us information about other misconduct that took place. And it started a momentum. It started a reinvestigation. It started to focus on how many lives had actually been destroyed by that administration. Not all of the prosecutors, but a small number of those top officials in there who had allowed these practices or these prosecutors to destroy lives with impunity. And the media was key to that. And ultimately, it led to Ken Thompson's incredible victory.
It's extraordinary. So I'm going to just pose one final question to the panel, and then we really do want to open it up to the audience, and there are mics that people can come down and ask questions. So, but the final question I really want to pose to everyone is, what do you think are the most effective reforms that we can put in place to really address prosecutorial accountability?
Good question. For every year a man is wrongfully convicted, let the prosecutor serve that year in prison. I'm sure there would be a total change of heart. No, but seriously, because that isn't realistic, unfortunately. Should be right in the right time. Prosecutors, of course, they should lose their law licenses. They should never be able to destroy anyone else's lives. And there should be civil consequences. Right now, there's a doctrine called prosecutorial immunity, where no matter how egregious the prosecutor's conduct at trial, no matter how intentional, you cannot sue a prosecutor directly, even if he admits that he used false evidence to convict you. He's absolutely immune from a civil lawsuit. That's why many defense attorneys or civil rights attorneys, I'm sure as Nina knows, have to come up with these creative theories in order to sue the city so that they can recover damages. So one way would be civil damages, the loss of license, and of course incarceration.
So in addition to what Jabbar said, I mean, we're trying to bring more transparency and accountability to the discipline process. In New York, Rebecca's probably the best one to talk about this, but I'm going to flip on you as the moderator. But our policy department worked with a lot of other advocates in New York State to this year pass the first ever Commission on Prosecutorial Conduct. So New York is now the only state in the country, it'll start in 2019, that has a special commission similar but not identical to those that judges have always had. Rather than having the bar as the only place, the bar still exists to discipline prosecutors and is the only entity with the power to actually discipline prosecutors as attorneys and members of the bar, but a place where there can be a public commission where citizens can bring complaints about serious prosecutorial misconduct. The details are still to be fully developed and worked out in the early part of next year, but essentially there will be an alternative mechanism where you can go that will not be shrouded in the kind of secrecy that the bar discipline process is, that will make recommendations directly to the governor about whether a prosecutor or an assistant prosecutor should be removed from office or otherwise disciplined. So that's one. We need to change the laws on pretrial discovery to make sure that what Cynthia described, which is the prosecutor has the sole decision about what pieces of paper, what tapes, what emails, what videos get turned over until the start of trial, are not left to that kind of discretion for so long. Many states, I will tell you, including Texas, in large part because of, though not exclusively, the work we did in Michael Morton's case, Texas actually went and dramatically changed their laws the following year to essentially move from a closed file system to an open file system. So prosecutors now have to turn over virtually all information that they possess, whether or not they believe it's helpful to the defense. It's not up to them anymore to make that determination. And many say it's actually easier because they don't have to sit there deciding, is this favorable, is this not, is it going to help, is it not, how close to the line is it? They just have to turn it over. There are some exceptions for witness privacy and safety for their own what's called work product, but essentially they turn it over. And similar to what Cynthia has recommended nationwide, in Texas, you not only have to turn it over, you have to file a written certification or say it on the record in court, certifying that you've complied with the law and listing everything that you've turned over. And there's a lot of advantages to that. You can be directly sanctioned by the court if you put in a false pleading. If you lie, it's a crime. Judges don't like it, as you know very well. You lie to me, you might get in a little trouble. You lie to a judge, you're going to be in a whole lot more trouble. There's actually some accountability and some confirmation there. And it also serves as a deterrent because when you actually have to prepare the list of what you're turning over, you might realize that you left something off accidentally because you've got to get organized, as many of us try to do every day. So those are just a few of the things that we're working on, but we're hopeful that those reforms and others can go a long way. And then elections. Everybody should vote. Not saying who you should vote for, not endorsing any particular candidates, but everybody should vote because the percentage of people that vote in DA elections is incredibly small. So you want to talk about a vote that has an impact? Voting in the primary, which is usually where it's decided because most local elections are one party only, voting in the primary for district attorney is one of the most important votes that you can exercise. And go to the candidate forums, ask questions about wrongful convictions, ask about their discovery policies, ask about what they do if a prosecutor in their office has been found by a court to have violated the law, even unintentionally. Hold them accountable and make your priorities known.
One of the things I found really sort of disturbing in my reporting was that the appellate courts don't automatically refer convictions that have been overturned to the disciplinary committees, even though the disciplinary committee is actually part of the appellate court. I mean, it's like basically across the hall. So, I just never really got why they didn't initiate action as soon as a conviction had been overturned. I mean, it's a pretty rare thing. It shows up in, it shows up in the media. It shows up in legal reviews. You tend to get, if you're in the field, a sense of what the appellate courts are up to on a day in, day out basis. And so it just seemed like that would be a pretty easy fix if you could just sort of mandate that you would at least report that. Because one of the things that former disciplinary committee officials had told me was that, well, we actually don't get that many complaints about prosecutorial misconduct. And then if you talk to people in the defense bar, as has been mentioned earlier in this panel about why that happens, there's a disincentive to file a complaint because action is so rare. So, and the first thing that the disciplinary committee does when they get a complaint is to turn it over to the prosecutor and give the prosecutor a chance to kind of defend themselves. And then it often sort of ends there. And so what's the point? You're basically going to alert your adversary to there being an allegation of misconduct, and you might have to work with that person again. And so why report anything if the appellate court's not, if the disciplinary committee's not going to do anything? So it seemed to me that there were some practical fixes that could be made there.
So just briefly, I would say mandatory data collection, that judges and prosecutor offices have to keep data on disciplinary actions, on failures to disclose evidence, on misconduct, and that information should be reported annually. So it may be that in a given office, it's really just 3 or 4 prosecutors who are committing most of these violations and probably need to be fired, or it may be the culture of the entire office. Either way, we need to know the extent and the scope of the misconduct going on in these offices.
Great, thanks. And I'm going to just encourage people to come down to the mic over here if you have any questions. And while we're waiting for people to come down, I do have a question from our digital community that I think is actually very relevant to Jabbar's case. So this is from Nancy Maradian Sordetto, who says, I've been watching a lot of documentaries, television shows about falsely convicted individuals. Why does our court system continue to use jailhouse snitches? Why is the defendant not allowed to give a full narrative account of his side of the story?
Oh, sure. Treating that in reverse order, a defendant is always, he's always allowed to give his narrative of the story because he has the opportunity to take the stand. But what happens in many cases is the defendant may have had problems with the law when he was young, and he doesn't want to be convicted by guilt by association, because he did something when he was a kid. If he takes the stand, the prosecutor will cross-examine him and imply that because he did A, he necessarily did B. So that's the first point. And, even though that's a decision that the defendant makes himself, most of the time he'll defer to his lawyer on that. And regarding jailhouse snitches, and there's a lot of scholarship. These two wonderful ladies, I think, can answer that question better. But I think that in some cases, there's some difficult cases that without jailhouse snitches, the prosecutors won't be able to bring a case. But that's virtually the worst type of evidence that you could imagine. Here it is, you have an individual who's in jail, who wants to get out, and all he needs to do is to say that Nina told me she did A, and that automatically gets me a deal. And there's been study after study where you had serial jailhouse snitches who've lied on 20 people, and some people were sent to death row. So I think law enforcement uses this because it's convenient, and they use it in difficult cases. Why they allow it, I'm not sure. Hopefully one day we'll get a precedent overturning that.
I think the closest I've seen to reform of jailhouse snitch testimony is in Illinois in death penalty cases, and in a couple other jurisdictions they've considered laws saying that a person cannot be convicted based solely on the testimony of a jailhouse snitch, that there has to be some other corroborating evidence. At a minimum, that should be the law everywhere.
Right, and a recent law that actually passed in Texas really creates a tracking system around informants. So it really requires now that certain elements are tracked about the informant, things like that person's criminal history, how many cases they've been an informant in, what was promised to them, what was conferred upon them. So these things are tracked and then have to be disclosed to the defense. And so far, Texas is the only state to have done it. So we're very hopeful that that will bear more fruit around the country. But I do want to turn to folks in the audience. So if you want to come up to the mic and ask your question.
Hello.
Can I be heard?
Yes.
Okay. I'm here as a parent and advocate for my son who was wrongfully convicted, forced into a plea bargain under Cy Vance, Manhattan District Attorney's Office. And I've been receiving I don't know how to explain it, but my son has been denied his due process. This is his first ever conviction, arrest seriously. They set his bail at $500,000. I witnessed people coming in there on attempted murder charges that didn't have $500,000 bail. I tried to submit character testimony and evidence to show that all the charges that they were bringing against my son were inflammatory and derogatory, and none of that was heard because we couldn't afford a $25,000 attorney or above. So as a mom and as a parent of 3 sons, I came here tonight to seek your assistance because as of today, my son was supposed to be released after he unwillfully, against his own will, against our will, took a plea bargain in which he has already served his time, and they denied him his conditional release date. And they're holding him in Malone Correctional Facility, in which I have not had a chance to speak to him since June. And they're telling me that they will not release my son until February. They're going to hold him in solitary confinement until this time. We've contacted the jail. We've tried to get information because we do understand that the reason why a person can be in solitary is due to an assault or violence of anything, in which the staff, the counselor, and the people have told me that there was no assault or fight that took place. And my son is not allowed to speak to me. We're not allowed to send him packages. We can only send him 1 publication at a time. Mail he has not received from us. Today was a court date in civil court because in the process of him being convicted, they're trying to take away the apartment in which he was inherited, and has really nothing to do with it, but because of the area of Manhattan which is in, and they can get $5,000 a month for that rent, they are harassing and bullying me and my family.
Ma'am, can I make a suggestion? It sounds like whoever's representing your son is not doing a very good job.
It was the legal aid department. We got rid of them. The judge told my son that he could not request another lawyer. And I'm sure you might know the judge, and I don't care I'm going to say her name, Judge Convisor in Manhattan Criminal Court. And then we were given an 18B lawyer.
So it sounds like you need someone to represent your son.
The cases have already been charged and convicted. His time has already been served.
I understand that, but to the extent your son is still locked up, he still has rights.
Yes.
And so it sounds like you need a referral for a lawyer to represent your son in the post-conviction stage so that he can get relief. And so what I would suggest is to come talk to somebody afterwards and see if they can make a referral to a lawyer who can help you.
Okay.
Thanks for your question.
Thank you.
Thanks.
Hi, good evening.
Good evening.
I first want to say thank you guys for this conversation because I truly enjoyed it, and thank you for sharing your time. My name is Mahassan. I was born and raised in New York, and a couple months ago I did my jury duty service, my grand jury duty service. And for those of you who don't know, the grand jury is responsible for hearing cases and making decisions as to whether or not it's going to go to trial. One of the first things that they told us was that, none of the grand juries, they don't dismiss. Only a very small percentage of cases dismiss. So it makes you feel like, we're just supposed to send all of the cases to trial. One of the cases that came before us was a young man who I felt the prosecutor was overcharging and basically trying to charge for a future crime because they were familiar with him. The officers were familiar with him. So they told us that, he's going to commit a crime in the future. And I said, when in America do we charge for future crimes? So thankfully the jury, I think, took the jury duty service seriously, and I spoke up. and I basically, told them how I felt about it, and we dismissed the case. And a couple people came to me afterwards and told me that some of the things that I said convinced them to change their votes. One of the women even said that, she was happy because some of her previous biases, I made her question herself, and she decided that she wanted to change her vote as well. My question is, because that made me so proud and I was just so happy. I was floating on air afterwards. What can me, as someone who's not an attorney, I don't have legal experience, what can I do or what kind of organization can I be a part of that would help me to be involved in something like that going forward?
The Innocence Project is a great organization. Actually, they do a great amount of work in that, and you can always donate to them. The Exoneration Initiative is another excellent organization that works. But more so voting. If you can control who's the district attorney, that has a huge impact on how these particular cases are handled. When Ken Thompson came in office, he, I think, designated $1 million for a conviction review unit. That was unheard of, to assign, career prosecutors for the sole purpose of digging into these wrongful convictions. So they took it seriously. But that wouldn't have happened had Ken Thompson not been elected. So if you can support the right candidate for district attorney's office, and the Queens election is coming up, so you have your opportunity to exercise your discretion in that one. Don't vote for Richard Brown. So I'm just saying.
The Innocence Project takes no position.
Yeah, the Innocence Project. This is Jabbar Collins on my own. But all playing aside, really, with respect to that, your vote is the most important thing.
Can I also say, I think just hearing that story from you is incredibly powerful as a juror, and we so rarely hear from jurors because when the case is over, people go home. So I thank you for coming to this forum, and I hope you feel empowered based on the experience you had. I would encourage you, and again, just like we're talking about when something happens in a courtroom and someone does something wrong, we tend to move on to the next case. I would encourage you to write a letter as a grand juror to the elected prosecutor or the head of the unit for whoever brought that case. If you remember the details, if you remember the date that happened, if you remember the officer's name, or you can find out, write to the police department and write to the district attorney, tell them what you recall, urge them to get the transcripts of that proceeding, and if your recollection is correct and an officer came in and said, I want to prosecute someone for what they might do in the future, there should be consequences both for that individual and for the assistant district attorney who brought those charges and kind of acquiesced in what sounds, from your description to be unlawful. And, it's like see something, say something. If we don't speak up when we see it happening, it's not going to change. And if nothing happens or you get blown off, you can call Joaquin and maybe he'll write a story.
Yeah, I was going to say, feel free to write to your local reporter.
And even posting on social media. I had a case a couple of years ago, a client of ours, Anthony Wright, one of the only Innocence Project clients ever to go on trial a second time after he was wrongly convicted the first time, and they put him on trial again despite DNA evidence, despite a lot of other evidence of innocence. The jury sat through a 3-week trial and acquitted him in 5 minutes. Wow. But after that happened, the jurors were mad, and they should have been. And they held a press conference of their own. They posted on their Facebook pages and on their Twitter accounts and on their Instagrams about how outraged they were. And there was a DA election the next year. There was a lot going on. And the quotes from the jurors who said what we saw was wrong and this was a waste of our time and our taxpayer money, and keeping this man in prison for 3 more weeks when he should never have had a trial at all was an outrage. That was much more powerful than me saying it. So, I thank you for your jury service and for speaking up, and I hope this won't be the last place you'll tell your story.
Well, another thing is they told us we can't speak about these cases.
Well,
so
if they
we never know how
prosecute you for
true that
coming
was.
here tonight, call us and we'll see. But there's nothing in all seriousness that prevents you. You might not be able to disclose what happened in the proceeding and give names, but you can certainly contact the DA, who is a law enforcement agency, and report what you saw.
Thank you.
Good evening. Good evening. Thank you guys for actually putting this together, first and foremost. I'm a product of mass incarceration. So before I go any further, let me just clarify real quick. I only have one question. I really had 3, but I broke it down to 1 because it's more beneficial for you guys to answer that question. In regards to Mr. Hines and the DA's office in Brooklyn, Mr. Hines was a DA for close to 4 decades. A lot of us was incarcerated as a result of Mr. Hines and his activities. A lot of us went to jail for doing nothing more than being innocent Afro-Americans. And as a result, we came home and we made sure that Mr. Hines was no longer in office. Ken Thomas didn't do that on his own, bruh. We stood behind Ken Thomas in the hood and made sure that happened. So we resolved that issue ourselves.
That's right.
And that's why I'm now also a journalist, independent from everybody else, to make sure that this stuff stops. Now, my question to you guys is, exactly what legislation are you putting forward to change the judicial system because it's broken?
Well, that's good. Well, first, yeah, I commend you and everyone else, of course, who supported Ken Thompson. Of course, no district attorney gets elected without the support of his people, and that's great what you did. I think the legislation that Nina discussed earlier, passing the first prosecutorial conduct commission in the nation, that was legislation that was pushed forward. And I hear that there are other states that are attempting to create their own commissions as a result of this. So I think that was a perfect example.
Jabbar's being very modest because he actually took several days off work to go up to Albany and tell his story and help make sure people understood the need for the legislation. So no one does it on their own. But also, in New York, we were talking a little bit about the laws in Texas and how they've been changed to require earlier disclosure of information. New York is one of 4 of the most restrictive states in the country in terms of when criminal defendants get access to the basic evidence against them. And many legislative sessions in a row, efforts to reform discovery have failed. Every year, we're like Charlie Brown in the football. We keep rushing up and trying to kick it again. One of these days, we're going to make contact. But in all seriousness, we really do need people in the community to contact their elected officials in the state assembly, the state senate, the governor's office, and talk about the need for reform in that area.
Right, and really educate folks in your community. If you're affiliated with, churches or schools, it's really important for people to just understand where New York stands on this discovery issue, which is 4th to the bottom. People don't get police reports, witness names, or witness statements until the eve of trial in New York, which is just shocking to people when we share that. So this is really information that, the public deserves to know, and the public should be demanding change in this area. So, sir, if you could show your question, please.
Hi. My name is General Parker, and I come here from Peoria, Illinois. And I met Maddy earlier this year as a Just Leadership cohort. And I had already been getting your newsletters anyway, but to meet her was just fantastic for me. But I got a question, but I got a couple comments because I got here late because I don't understand your traffic yet. But
welcome to New York.
and I guess the driver didn't either. He let me off 2 blocks down, so I don't know what. But the first one I had, when there was a question about the racism, and I think, Ms. Jones, you said they're not really racist, they just, this discretion. No, I believe this whole system is set up to be racist. This system ain't broken. It's working just like they planned it. Working just like they set it up. And then I think you kind of described racism because you said the system is set up this way, the judges, they have their biases, and if they don't like black people, that's the whole definition of racism, is you have a system that deprives another race, the privileges and benefits, okay? So, anytime a little boy here can be in jail for 2 years, and get beat up and raped and all that, and never even go to court, never even been charged. And then you have a white boy somewhere else can commit murder, and the judge lets him off for affluency. No, that's a racist system. So that's the only way I can see it. It's just straight up racist.
So maybe you misunderstood me. I said it's not the only reason that there are racial and ethnic disparities. It's not the sole cause of racial and ethnic disparities that prosecutors, police, and judges are racist. Some of them are, but that's not the only reason. My point was, if you are racist, but you have no power, you can just have that view, but you don't have the ability to make decisions about whether, someone's going to be held on bail, whether someone's going to do 5 years. But if you have racial bias and you have discretionary authority, That's what's causing the racial and ethnic disparities in the criminal justice system, not just people, individuals being racist. It's having discretion and how you use the discretion.
Well, see, then you talk about the people that we elect into these positions, okay? Well, they get elected because basically when they talk about how many blacks they put away, you know, and they talk about the drug dealers and the thugs and all those cold words and the crack whores, you know. I mean, they're not going to say I arrested Susie Homemaker in the suburbs, okay, and expect to get elected. So I do believe it's, and we help in that too, white and black, you know. There's black people that's just as racist and racist against other black people and help this system of white supremacy. So we got to work on that too. But I heard you also say something about what can we do, but I didn't hear anybody say anything about removing absolute immunity.
We talked about moving.
Actually, yeah, we did
I told
talk.
you I came late, so.
Okay.
No, that's
yeah.
okay.
We did talk
No,
about
thank
that.
you,
I think
brother.
But can you tell us what your
immunity-
question is, though?
Well, I want to ask, when all these things go on, why don't more lawyers, I mean, even lawyers on the case, why don't they turn these prosecutors in? You know, I had 2 cases. One was in St. Louis, and I was just fighting for my son. And I had a prosecutor get involved in that case. Then I had another one in Peoria when I was running for office.
Actually, brother, though, we did talk about that. You missed that part of the discussion. But Nina did address that question about not filing complaints against prosecutors why defense attorneys don't file complaints against prosecutors who they have to work with every day. So we did address that in detail.
So what you're saying is more important for them to be able to go to work with these people every day than to have somebody's life.
No. So if I'm a public defender and I have 50 clients, there's the prosecutor who did my first client wrong is probably the same prosecutor in those other cases.
Yeah.
And if I go against that prosecutor, I'm going to have to go back to court and ask for a favor or some lenient treatment for client number 2 and number 3, all the way up to number 25. And that prosecutor might not be willing to give my client the benefit of the doubt or favorable treatment if I turned him in with respect to the first client. That's why the Innocence Project is saying they're not in the courtroom day to day with prosecutors. They've been filing those complaints. So it is happening. It's just a question of who files the complaint. The media is alerting folks, and Innocence Project, and there's another group called the Civil Rights Corps based in D.C. They've been filing complaints against prosecutors. So it's happening more than it usually does, but not by lying public defenders.
But isn't there one of the canons that say that
Sorry,
you
brother.
have
And to be fair, brother, we have a lot of other people who have to.
But
I will talk to you after the program. I'll wait around and you and I can talk in the back.
Jabbar's going to
Fair
give you all
enough?
his parking tips, too, because he
Okay,
drives
brother.
from New Jersey to the city. He knows how to go.
Thank you for coming
Thank you,
from
brother.
Illinois. We have time actually for one more question here, and then we're going to just close up. So I really am sorry to everyone that's been in line, but we will be available absolutely to talk to you because we'll have some time right after for some small bites and some drinks, and we really do encourage everyone to join us. But let's just hear a final question if we can. We can get everyone?
Okay, great.
All right, how you doing?
Hey, brother.
my name is Anand Darawat, and I got love for everybody that we're talking about, all the agencies, all the people, and I'm just trying to give, like Nina said something, I'm trying to give the wave of the future as well. Now, when you're in the subway and you see on the subway tracks, you see a couple rats, you know that's not the extent of the amount of rats in the system. So what I'm trying to say is, you know, I'm a Hindu, Brahmin, nonviolent, peaceful preacher. And I got some, you know, a network that's visible and invisible. Invisible does not mean imaginary. And what I'm trying to explain is I heard you, Jabbar, say something that you said was not realistic that I've actually been pushing. As far as every cop, every district attorney, and every judge, if you are trying to put somebody in jail, why shouldn't you be held to be in jail for the same amount of time you're trying to put? Because like I said in an event recently, if I bet on the Knicks with everybody here and I win and I collect, but then I lose and I don't pay, then how can I ever show my face in this town again?
So what's your question exactly, brother?
I'll get to that. What I explained in another event is that I'm doing a little magic trick, and I'm going to let everybody that's here participate, and you will be able to control what the outcome, which is very...
But we got to move quickly. We're about to wrap up, and somebody else has a question. Just ask us your question.
Please. Are you willing to participate in stopping the consumption of meat, fish, and eggs, which is the murder and the caging of other groups that have been discriminated against? Because once you eat that hate, fear, and anxiety, and that depression, you always see everybody as a threat. And right now, the criminal justice system is just organized vengeance. There's no justice involved at all. And if you could all stop your consumption of that, we wouldn't have these issues. And
brother, I appreciate, but that's not the forum. That's not the forum from this. We're talking about people's lives being taken away, and this is a different.
Eating a diet of murder makes people murder, and
I'll be happy to address that after. I'll be happy to address that after that, but not in this forum.
I'll be here to speak to
Thank you.
Ready.
You good?
Good evening. My name is Linda Kumalo. My brother's case, 2013, Justice Sotomayor's opinion made national news because the prosecutor, Sam Ponder in Texas, made a racial remark during the trial saying, you have all that money and you have African Americans and Hispanics. Didn't a light bulb go off in your head that this was a drug deal? That was the argument taken to the Supreme Court. It was denied because the defense attorney did not object. Well, that's the reason we went to the Supreme Court, is because the attorney did not do his job. That case is still being discussed wherever, or rather Sotomayor is still being asked about their decision. That was just a small part of what happened.
Tell us what your question is.
Okay, it's so many bites. Jury selection, there were either 39 people or 41 people, only one black woman was there.
I know, but you got to get to your question, because look at the line of people behind you.
Okay, all right. The key witness was arrested with drugs after that in Houston. Houston DA gave the case to the federal prosecutor in San Antonio. He decided that the drugs did not belong to this guy. That guy became the key witness in my brother's case.
So, sister, what is your question, my sister?
The question is, how can a case that's in Houston, and it's a state case, be taken or given to the federal prosecutor in San Antonio in a different jurisdiction, and he's the one that decides that the drugs did not belong to him, yet everything else happened in a different jurisdiction, different city?
So it's the short answer is that some criminal conduct violates state law and federal law, and you can be prosecuted in both without there being a double jeopardy problem. I don't know that that's what happened in your brother's case, but some things that are a crime, it's a state crime and it can be a federal crime. That's the short answer to your question.
Thank you.
And we can also take some more time after, but I do want to get another question here, please. Thank you, though.
Hi, my name is Nawana. I should say we are. My husband has been wrongfully convicted for 30 years now. One thing I do want to say, Jabbar, I know you personally. I don't know if you remember me. However, it was one thing that Jabbar had told me once he got out was to look at the material witness order. So this was, I'm not sure how long you've been home now, but now we see that's one of the biggest issues. But my question is now to you all is that the fact of the matter that the judge in the case was the one that said that he never signed the material witness. However, when we finally got our hands on it, it's the same judge that said he did not sign it. So for 30 years that we've been fighting to get him out for a crime he did not commit, he was not charged with, they already knew that he did not shoot anyone, he did not kill anybody, but now 30 years, I'm 50, his mom is 72, and we're fighting, and it's like when you go to, we don't have $25,000 for an attorney. I've had like 2 or 3 attorneys that were looking into helping us. And I'm grateful for Ken Thompson because I happened to meet him on the street. He took my information, he was on it. And then 2 weeks before he got sick, everything went downhill after that. So now, again, my question to you all is that how do I, How do we, for 30 years, this man has been sitting in prison for a crime he has not committed, for a crime he did not commit, but every phone call to this new district attorney office, I'm not getting any answers. I've reached out to everybody. I watched every documentary. I wrote the Innocence Project. I wrote everybody that I could possibly write, and I'm not getting any help, and I would like to get some help.
Well, the Innocence Project is here tonight. So, and we're going to be here a little bit after the panel, so you should come up to the Innocence Project folks and give them some information so that they can follow up.
Okay, thank you.
Thank you. Do we have time for a couple more? Okay, great, thank you.
Hi, I'm Diana. I'm here on behalf of my son, Ronald Williams. He was actually wrongfully convicted for 100 years for a crime that he didn't commit. There's actually evidence to prove that he didn't commit these crimes, but the judge didn't allow the evidence to come into the trial, including DNA evidence, statements from co-defendants. So my question to you is, like, when there is, I have several questions, but let me just ask this one. When there's a case with like co-defendants involved, right, that's given statements as proof, like who was there, right, should a judge allow a defendant to have a separate trial? Because they did not allow my son to have a separate trial. And there was a lot of motions that was put in by my paid attorney that was never answered. And then as we was winning hearings, they dismissed my paid attorney on some bogus charges. It gave us an 18-point-B lawyer to represent my son, which he didn't represent my son, he was just there. So I need help. And I don't have any more money. I know I have several questions. I'm gonna wait till after so I can speak to you guys.
Okay.
We appreciate it, and we're happy to talk to you after. As soon as we conclude, we're happy to chat in the back.
Okay, so my question is, I understand prosecutors have a lot of power. So my question is, like, for the judges, right, could step up against the prosecutors doing wrong, right? What about when the judge is doing wrong? Who's going after the judge? How do we go about that?
Great, so the question is really about addressing judicial conduct, so.
Correct.
Sure, so in New York, there is a commission called the Commission on Judicial Conduct, and it is a state commission. You can file a complaint against the judge.
So I could do that myself
You can go online and look up the Commission on Judicial Conduct, and there's a place to file a complaint. And you should be prepared. It's a slow process that takes a long time, but there is a place, and it actually is a process that in many ways has had a lot more respect within certain communities than the process for disciplining lawyers, prosecutors, or defendants. It's a little more public, and I am so sorry for what's happened to you and your son, and I think we're seeing tonight so many people coming here who are, really confused and lost in the process and have been fighting so hard. I mean, you should just, all of you, take comfort in the fact that many of our clients who are now free had many years where nobody but their families believed in them, didn't quit, ultimately got relief. It doesn't happen to enough people. It doesn't happen to everyone. But please know what you mean to your loved ones who are inside, and the fact that you're taking your time to come to places like this and do your research. Sometimes it really does pay off. So I wish you luck. And just know, for those of you who are out there listening and watching and in the audience, we have more than 6,000 people who've written to us from across the country whose requests we're reviewing. If we don't return your phone calls right away, we don't respond to your mail right away, it's not because we don't care, it's because we're trying one at a time to get to all the people who've written to us. But for those of you who come tonight, thank you for coming, and we hope you find some.
And I think we have time
support.
for just one more question. I just want to make sure we get to you.
Good evening, everyone. My name is Tawana Guilford, and I am going to actually speak with Rebecca after. I am the sister of a young man who was wrongfully incarcerated, sentenced to 6 years. So I'll just make a blanket statement of requesting transparency and accountability. And those are the key factors in my brother's case. And I'll be brief. I'm not going to ask questions. I'm just going to offer some suggestions for reform or some things to consider when you're doing legislation. So from the beginning, my brother was arrested with an individual on the stairwell of a NYCHA housing project. And as we all know, there are no cameras there, and there are special police that are assigned to police service areas of housing projects. So the sole witness in my brother's case is him, another individual who was arrested on the staircase with drugs in his possession, who accepted full responsibility of the drugs and said my brother was stopped already as he was descending the staircase. One officer testified against both.
But you don't want to go into so many details on the facts in this forum.
I'm going to move on. I really am.
But just tell us what your question or comment is.
So I am asking for accountability of the officer, because the question at trial was, who do you believe? Do you believe these two individuals, or do you believe this officer? We never had access to the officer's record. We found out after they both lost their case that the officer is a derelict cop, and he actually has similar arrests, similar wrongful arrests, similar legal actions against him, but we were never given access to the record. So we're asking for more accountability and more transparency. We've gone to CCRB, the police department, and we were denied those records. Also, we have put in a 440, a 330, an appeal, and we have not gotten any positive outcome. He is under a special review, an innocence review by the special narcotics prosecutor. There is no accountability there. That has been ongoing for a year, and no one is telling her when to end the review. She's accountable to no one.
Can I ask you a question? Have you all filed a complaint with the Citizens Complaint Review?
With the CCRB, I think.
We have.
In your brother's case?
50A is what prevents us from getting any positive outcome in his case. So we're just requesting that, in a non-DNA case, can some of the people who are challenging their convictions have some type of support? Because with the Innocence Project, DNA helps to exonerate a lot of people, but in my brother's case, the only thing that could have exonerated him was the officer's record.
Right, and this also sounds like another question about sort of how we can kind of connect you potentially to some folks that can be helpful, and we'd be really happy to talk to you as soon as we conclude. I'm just getting signals that I think we do have to wrap up, but I really am grateful for your question, and I do want to just kind of conclude just by saying that, we've heard a lot tonight about the guilty plea problem and about sort of the risk to the innocent of pleading guilty to crimes they did not commit. And so we really wanted to close tonight by sharing with you that we've launched an online campaign. It's www.guiltypleaproblem.org, and it really tells the stories of people who have pled guilty to crimes they didn't commit. And our first series really talked about what people are facing at the trial level. We just released a second series that really talks about what people are facing post-conviction and the plea problem there. And so we really wanted to conclude by just showing a short video from that series. We want to encourage people to take a look at that, to share it with your community, www.guiltypleaproblem.org. And so we're going to just show that short video. Right after, we're going to have some food, some wine. We really ask that everyone join us and are happy to talk to the people that had questions, about their individual cases. So we really thank everyone for coming out tonight and really thank our distinguished panelists. Thank you so much to all of you.
It was hell.
You put me in a dilemma.
And I had to take back everything I stand for and believed in.
Try going to bed at night and laying there and thinking, I'm going to take a shot, go to trial.
I took this plea out of fear because I didn't want to spend the rest of my life in prison.
I'd rather have secured freedom than roll the dice with the American justice system again.
Take a look, and thank you again to everyone for coming out, and please do join us. We're happy to take your questions too. Thanks.